Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. We'll hear argument in 4 cases this morning. First is 2337, Occidental Permian versus Citation 2002 investment from Reagan County and the 8th Court of Appeals District. Justices Huddle and Young are not participating in that case. Then next are 2 cases that are consolidated. 23-138, Encore Electric Delivery against Wilbarger County Appraisal District, and 23-145, the Mills Central Appraisal District versus Encore Electric. The first from Wilbarger County and the 7th Court of Appeals District, and the second from Mills County and the 3rd Court of Appeals District. And then finally, 23-376, Fossil Group versus Harris from Collin County and the 5th Court of Appeals District. The court has allotted 20 minutes per side, and the cases, including the consolidated case, and we'll take a brief break between the arguments, completing them before the lunch recess. The arguments are being webcast live this morning and will be available in the court's archives later on. We're ready for argument in 2337, Occidental Permian versus Citation.
May it please the court, Ms. Stokes will present argument for the petitioner. Petitioner is reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. The Court of Appeals held that all means all in this mineral assignment, but the key interpretive question is all of what? The Shell Citation assignment here says all means all of the property described in Exhibit A. And this court has told us that such commonly used language requires us to look to Exhibit A to determine what interest was assigned. Exhibit A here contains express, specific depth limitations that unambiguously limit the scope of the interest assigned, and the Court of Appeals erred in refusing to enforce that language as written.
Are they depth limitations or depth descriptions?
I think they are limitations. You could call them both. They are describing the property assigned. I think an integral part of three-dimensional interest, like mineral interest under the ground. Depth assignments are common. The descriptions are common and an integral part of the description. And here they do limit the interest assigned as well.
So how would we distinguish this case from Piranha Partners that had a description that involved land and associated wells in the northwest corner of part of one lease? We said that was descriptive and not a limitation on the conveyance itself.
Yes, Your Honor. I think, first of all, Piranha Partners is the case that directs us to look to Exhibit A to determine the interest assigned. The problem in Piranha Partners is this court found, and I think the dissent was also in agreement, that Exhibit A was at least ambiguous, if not completely unenforceable, because it didn't adequately identify the property assigned. So the majority looked elsewhere. In this case, we have unambiguous descriptions of the property, unlike in Piranha Partners. I think in Piranha Partners, if we had had an unambiguous description like we had here, that would have been the end of the interpretive inquiry. And I think if the court would turn to tab 2 in the bench book, they can see that there's 6 columns in Exhibit A, and they all tie, they're describing the property, and they all tie to the specific grants in the assignment. The assignment grants the following property, which it defines in 3 specific grants. And the first grant says we're giving you the oil and gas, fee, mineral, and leasehold estates described in Exhibit A. And you can see that the first 5 columns give you the lease number, they tell you where it's recorded, they tell you the parties to the lease, they describe the tract within the lease by survey, block, section, and often by depth. And then the number 5 tells you the interest assigned in the tract, which is the type of interest, working interest, overriding royalty interest, whether it's fractional. And then the column 6 is describing the grant in the third specific granting clause, which is granting contracts and agreements affecting the property described in Exhibit A.
So how do we know, that the description in Exhibit A is not, does not contain incorrect information or omissions, right? So, because there's the provision that says we're granting all of the interest, even if Exhibit A describes it incorrectly or omits it.
Right.
And it seems plausible that you could look at the depths that are not described in Exhibit A, but nevertheless, belong to the grantor as just having been omitted.
So a couple of responses to that, Your Honor. First, no one has ever contended, either the Court of Appeals or Citation, that depths were incorrectly described or incorrectly omitted from Exhibit A. On the contrary, they say they were included. Second of all,
I think they said they're included in the grant, but that they're omitted from column 4.
They don't say that they were, they say those are merely informational describing the third-party agreements. They do not regard that as a description of the property assigned, so they don't argue that anything was omitted from it or that it matters that it was omitted from it.
Did Shell actually own all of the interests at different depths that were not described? So for example, column 4, the first one says, from the surface to the base of the Lower Sprayberry Formation. Did Shell actually own everything below the base of the Lower Sprayberry or below the Lower Sprayberry?
It is undisputed that Shell owned greater rights than those
But
shallow
all
rights.
of these that are described, Shell actually owned? Like all rights below 7,000 feet in southeast quarter, 6,050 feet in the northeast quarter, 6,900 feet and all that. All rights below those. Do we know that Shell, in fact, owned all rights above those?
So the whole dispute, as the disputed interest, which is a subset of the interest conveyed in Exhibit A, we know that Shell owned more because that's why Citation sued us, is because they say that they have those deep rights that Shell owned at the time. And I think if the court turned to tab 4, you can see the contrast between the language in the Shell Citation assignment narrowly describing these depth limitations, and then the Shell Altura assignment, which is what Oxy claims under, which has the extremely broad language that I believe Citation is trying to import into their own assignment. It says, we're giving you all the leases, full stop, in Exhibit A1. We're also giving you all the interests we own in Reagan County. And then when you get to Exhibit A1, it's just listing the leases. That's it. It's really just the first 3 columns. The way that Citation wants to take the first 3 columns and say that's the only property description, and we get all the leases. That's actually what happened in the Altura lease. Then, and B1 of the Altura assignment, they say in all caps, no retained assets in the county. And that is the type of grant of everything that Shell owned in Reagan County that Citation is arguing that they got in. And I think the difference shows you the different language was used.
Go ahead.
Please go ahead.
Are there any of the track descriptions that are not depth limited? Most of the ones I see do seem to have depth references, but are there any that are not?
That none of the disputed interests all of the disputed interests are depth limited. There
Or
are,
at least
Your
there
Honor.
are depth figures, whether they're limited or not, I guess is in
Right,
dispute, but there are
yes,
depths
there are depth
listed.
descriptions. There are other interests in the 51-page document that are not depth limited or that give deep rights in them,
But
and those are not at
in
issue
dispute.
here.
Okay,
Yes.
so let me ask you this, under the track descriptions, are there any cases in which the track descriptions saying, southwest quarter of section 6 does not fully describe all the land that's covered by the lease number listed in column 1?
The record does not reflect, you're saying, could you take all
In
the
other words,
quarters
is
and
it
add them
not
up?
only depth, what I'm trying to figure out is, does the track description describe the whole lease in term, when it's saying southwest quarter of what have you, Is that the whole area
No,
covered by
it's-
all of these leases
These
or
are
not?
tracks within the lease, portions of the lease.
So why should we treat, if that's true, if column 4 is not fully describing the whole lease, it's only describing a tract within the lease, then I guess your position would be the other tracts within that lease are not depth limited?
They're not given the other tracks within the lease. They're only given, 1 through 5 is describing what they're given. They're given this particular percentage interest in a tract to a depth within the lease. And that's why these, so you have to look at 1 through 5 together to figure out what's being given. If they were just giving you all the leases, they could have stopped after the 3rd column. Or if they were giving you all the tracts within these, particular tracks within the lease, they could have stopped right there too, and they didn't.
I go back to the provision that says it is the intent of this assignment to transfer and convey all rights and interests owned by Shell Western in the leases described herein, even if they're incorrectly described. And that you could certainly read that to be saying, look, we're not going to put all our eggs in the basket of exactly what Exhibit A says.
Your Honor, I think what it says is, it's saying the leases or other rights described herein, so it is referring you back to the description of the property assigned in Exhibit A. It is not saying everything I own, and it is telling, what Shell is saying is, in the 3 specific grants in Exhibit A, I meant what I said, that you get these interests even if I incorrectly described or incorrectly omitted. Say I transposed some numbers in one of the columns, or I forgot to mention the section number in the tract description. And it also says, and whether or not Shell had title to the assigned interest at the time of the assignment, even if they later got title, as long as they didn't pay new consideration for it. So this is a situation where they are trying to say, yes, I intended to grant you what I just said I granted you, even if there are some inadvertent mistakes. And again, there's no allegation in this case that there were any mistakes in the Exhibit A. And this is not a case like this court's opinion in Davis versus Mueller, where we had a general grant that said, it is my intent to give you, if it wasn't clear, to give you everything I own in Harrison County. That would be, we would have a very different case if that's what it said.
It's difficult because one paragraph says, I'm granting you what's in Exhibit A, and that's easy enough. And then another paragraph says, I'm granting you all my interest, even if it's omitted from Exhibit A.
Well, it says incorrectly if it's incorrectly omitted. And Your Honor, that we have to remember that paragraph comes under the terms and conditions to which the assignment is subject. And this court said in Averett versus Grande, Inc., that subject to limits the estate granted. So these are limitations, not expansions on it. And again,
Is it a limitation to describe the lease? Is it a limitation on the conveyance of the lease to describe the lease? In other words, if you add descriptive language like a particular well that's already existing on the lease, a particular depth of drilling that's already occurred on the lease, is that a limitation to include that description that affects one portion of the lease?
are you saying in the paragraph we're talking about that the Court of Appeals relied on, or are you going back to Exhibit A?
Just in general, because the granting language is all right and title in a lease, right? And so then the question is, as herein described, is that a limitation on the lease, or is it just a description, telling you which lease is conveyed?
Well, it's saying leases are the rights described herein, and I don't think there's been any dispute that described herein means described in the grants in Exhibit A. Again, it's just referring you back, and the purpose of that clause being to make sure that they capture everything described in Exhibit A, even if it's incorrect. And the all right title and interest is classic quit claim language that is saying it's still all of what, but it's also saying, I'm giving you my interest, if any. I'm not warranting title, which on page 2 of the assignment in tab 1, they expressly disclaim the warranty. So that's why that language was in Piranha Partners, it was in Petropo, it's a very common language, and it doesn't change the specific grant. You still have to look at what the specific grant was, all right title and interest and what.
I guess I don't really see why the subject to language helps us very much. If it's saying it's subject to these terms, doesn't that just mean these terms apply?
Yes, I mean, I think it's telling you this is, we are not broadening the grant, we are not, and that's,
Well, it's saying whether it's incorrectly described or omitted, and if it's true that subject to means that you can't broaden it, then does that word omitted become surplusage?
no, I don't think so. It's a term that's saying if it's incorrectly omitted.
If it's incorrectly omitted, it was omitted, but it was omitted incorrectly, and we want to include it.
Yes.
And so if you're saying subject to is only a term of limitation, then omitted has no meaning.
Well, I'm saying the subject to is what this court has said is is classic words of limitation, and I think terms and conditions are themselves terms of limitation, even if you're not describing the property granted in them, you're still defining the interest assigned.
What happens if we think that all this is ambiguous?
So I think there's a couple of things. I think it's not controlling, but it's significant that both of the courts below and all the parties have always believed it's unambiguous. I think citation to argue that, I think they rely on extrinsic evidence to argue their interpretation of it, whereas we don't.
But assuming we were to hold, and again, I'm not saying we will, but assuming
Yes.
we were to hold it was ambiguous without looking at extrinsic evidence, what happens then?
If you hold it's ambiguous, then obviously we would have to remand it for a jury to decide what it means. But I don't think there's anything ambiguous about, again, as the commentators have described, depth descriptions are extremely common, and they are a common and integral part of a description, such as Exhibit A of mineral interest. So there's no textual hook, I think, to argue that those words don't mean what they say, and that there's two equally reasonable interpretations.
Focusing on the first granting clause, what is a oil and gas fee, mineral, and leasehold estate? What is an estate?
So an estate is an interest in land, as opposed to the land itself. And here they've listed fee interest, mineral interest, a leasehold interest. And most of these are,
I mean, which column describes an estate?
so the interest assigned column describes the type of interest, the overriding royalty, working interest. There are two in the leases, and then those interests derive from leases, right? Working interest and overriding royalty interests derive from leases. There are two at the late in the assignment. There is one fee assignment and one overriding royalty interest assignment, but the rest are specific interests derived from leases, and those are the estates. And again, that's why the quick claim language, they're not giving you, saying they have the land themselves, giving you title of the land. They're saying what interest I have in it, I'm giving to you, described in Exhibit A, I'm giving to you.
Any other questions? Thank you, Ms. Stokes.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Boyce will present argument for the respondent.
May it please the court. This court should affirm the Court of Appeals judgment and reject Oxy's erroneous effort to insert a shallow versus deep dichotomy in this assignment that isn't in the words and doesn't exist. We know this based on what the assignment and Exhibit A say and what they don't say. Before I start unpacking that, I want to follow up on one of Justice Busby's questions and push back on this notion that there is somehow only a subset of the leases that are being adjudicated here. All of the leases described in Exhibit A are on the table in this case. All of them were addressed and encompassed by the summary judgment order. All of them were encompassed by the order granting permission to appeal. All of them are encompassed by the competing motions for summary judgment. And so in direct answer to your question, Justice Busby, what the court sees when it looks at the entirety of Exhibit A is that there are some shallow references, some middle references, some deep references, and some leases for which there is no depth limitation or depth reference at all, which goes to the point that the shallow versus deep dichotomy that Oxy prevailed on the trial court to accept is simply erroneous. It doesn't work. Let's talk about what the assignment says in its granting language. The way that we've set this out in the oral argument exhibits that the court has is that there is a general grant, which is also the second paragraph 3 at the bottom of page 1, and then there are 2 specific grants above it. And individually and in concert, those convey to Citation all. The question then is, all of what? The answer is all of Shell's right, title, and interests in the leases that are being conveyed without a shallow versus deep distinction that's being made. We know this because the language in the general grant, which is the second paragraph 3, could not be a more express description of intent. It is the intent of this assignment to transfer. And then it doesn't stop there. It goes on and it says, and Shell Western does hereby convey and transfer to Citation all rights and interests now owned by Shell Western, its successors and assigns in the leases that are in Exhibit A. And so,
in the leases described herein.
in the leases
And
described
what are
here.
the leases, is that herein meaning this document or Exhibit A?
I think it means both. I mean, following the roadmap of Piranha, Justice Boyd, I think what the court does is construe the assignment together with its
So
exhibit.
described herein, we can go then back up to the first paragraph 1, which says all of Shell Western's right, title, and interest in and to the oil and gas fee, mineral, and leasehold estates described in Exhibit A, right?
That's part of it. That's not all of it.
what's described herein?
What's described here, I think the way to look at this is to construe the assignment and its accompanying exhibit as an unambiguous whole, which is exactly what the court did in Piranha, which is why Piranha is the roadmap to affirmance of the Court of Appeals judgment in this case. Because if you start parsing it, the first specific grant, as the court just recited, refers to the assignment of the oil and gas fee, mineral, and leasehold estates. And let's be clear what's going on here. This is an assignment of the leasehold interest. Then we
See,
go
and
to,
that's why this is curious to me, is especially with the language that Justice Blacklock has asked about regardless of whether same may be incorrectly described or omitted from Exhibit A, makes it sound like it's possibly granting something broader than what's described in Exhibit A. It could be if Exhibit A doesn't accurately or correctly describe it. So, well, what is it? It's the leases and other rights described herein. Well, then what's described herein in the first paragraph 1 is all oil and gas fee, mineral, and leasehold estates described in Exhibit A. And then you go to Exhibit A, and it seems to me that if the estate being described is column 4, then you lose. But if the estate is column 1, the lease, or column, I guess 1, 2, and 3 combined, the lease, then you win, right? I mean, that's how it seems to me.
it is 1, 2, and 3 that's being conveyed, but I want to unpack
what's
your
the
observation
estate?
a little bit, if I may, Your Honor, because I think what the court can work its way through this assignment document. Page 1 of the assignment, paragraph 1 is the language you've just focused on. Paragraph 2 covers surface rights and surface access, not really part of this fight. And then here's the key, a key, which is the first paragraph 3, what we call the second granting clause. We've set that out on page 2 of the oral argument exhibits. And Oxy never touches this. Oxy doesn't have an answer for this, because if you look at the second granting specific grant, the first paragraph 3, it refers to all of Shell Western's right, title, and interest to any contracts or agreements including, but not limited to, a list. And then here's the language that Oxy refuses to address. And rights above or below certain footage depths or geological formations affecting the property described in Exhibit A. And I would urge the court to focus on that language because I think it tells us at least two things. Number one, the leases themselves are contracts or agreements. And number two, what Oxy has never answered, and you won't find this addressed in their brief on the merits, is what purpose does the conveyance of rights above or below serve if, as Oxy contends, the assignment is limited to just rights above, or so-called shallow rights? That language is rendered superfluous and meaningless under Oxy's interpretation, which is why there is not an ambiguity here, because in order to have an ambiguity, you have to have two reasonable competing interpretations, and Oxy's is not reasonable because it reads language right out of the assignment.
What are the depth descriptions in Exhibit A therefore, if we're talking about the question of superfluous verbiage?
The depth references in column 4 of Exhibit A under tract descriptions pertain to the burdens that are created by the agreements and other obligations that are listed in column 6. That's the connection. And I can give you a for instance of an example that illustrates that. For example, if you look at page 1868, which is in our oral argument exhibits, there's a reference to a farm-out agreement between Allied Chemical and Shell dated November 26th of 65. That's one of the agreements listed in column 6. One of the agreements to which the assignment is subject to in the heading of column 6. And then if you go to page 2193 of the clerk's record, you'll see the corresponding farm-out agreement that explains where the depth references come from and where the overriding royalty of 0.1625 comes from. That's just one illustration.
It seems to me, I mean, I'm not saying there isn't a way we can sort this out as a matter of law, but it sure would be nice to know what was going on. I mean, you have an agreement that says, look, we're going to grant you what's in Exhibit A. Exhibit A has all these detailed depth references. I mean, if you're the grantee and, all right, I'm getting what's in Exhibit A, I better look at Exhibit A, you're going to say, well, this sure looks like I'm not getting everything I think I'm getting, since it has these specific references to pieces of the depth. And I don't know how any party in that transaction who was responsibly looking at all of this could have looked at this and been fine with Exhibit A and think they get the whole thing.
I think if you recognize that the tract depth references or depth descriptions, to use Justice Bland's term in column 4, relate to the burdens that are created by the column 6 agreements, it makes perfect sense. And so I'd answer your observation in two ways. Number one, we would submit that the entirety of Exhibit A explains what's going on, and I've given you an example that links a farm-out agreement with the depth references that are contained in column 4. But even if the court concludes that you can't connect all the dots, that it's not complete within the four corners of Exhibit A, that takes us back to Piranha and the analysis in Piranha, which says we're going to review the exhibit in light of the accompanying assigning language. And the dispute in Piranha was you've got the assignment, and then you've got an exhibit to it that contains a well reference, a tract reference, and a reference to the lease. The court said you can't tell from that information what the scope of the assignment was, so what does the court do? It goes back to the assignment language itself to find the textual clues, the textual indicators that indicate it was the entire lease that was assigned. It was not just one well. It was not just one tract. And I think
What does column 5 is column 5, which is entitled Interest Assigned and Described Tract, is that disclosing that a lease is burdened by some other kind of assignment, or is that saying this is the percentage that Shell is assigning to Citation? In other words, is there a reference between the two, assignment between the two parties that's contained in this conveyance, or is this some other reference?
The references in column 5 pertain to the burdens created by the agreements in column 6, to which the assignment is subject to. And so I'll give you the specific example again. If you go to a farm-out agreement that appears at page 2193 of the clerk's record, that corresponds to the farm-out agreement that is listed at page 1868, which is part of Exhibit A. So
But
that's
it's
an
some sort of
example.
third party.
It is putting the world on notice that the leases that are being conveyed in their entirety are subject to various burdens. Burdens from farm-out agreements, burdens from unit agreements, burdens from gas purchase agreements. And one of the things that I would focus.
And so the answer is it's agreements that are not this agreement that 5 is referring to, because 5 goes back to 4. 5 says interest assigned and described tract. 4 is the tract description.
I think it's the way to look at it is 4, 5, and 6 are each providing additional components of information about the burdens that accompany the leases that are being signed. And so I think that's a key point to remember here. And I also want to, highlight a couple of points about some of the things that the court's been presented with Oxy's exhibits. We are not contending, we've never contended, that only a farm-out agreement can have depth references that are reflected in columns 4, 5, and 6. They could come from a unit agreement. They could come from a gas purchase agreement. At pages 46 and 47 of our brief on the merits, we cite cases for the example of the depth references being associated with a farm-out agreement or a unit agreement. We have an additional citation that I can offer the court for an example of depth references in association with a gas purchase contract. That's shown in the Tenneco.
Do you know, as a percentage of the total grant that you're claiming, like what percent is the stuff that you might say is omitted from Exhibit A? If you read Exhibit A to be describing particular depths. Like, so what's at stake here? You agree some was granted. What's the delta between the whole thing and what you agree was granted?
Well, we haven't tried to put it in percentage terms like that, and I guess I want to make sure that I'm understanding and answering your questions.
5%, 1%, 50%?
We're not-
Do you have
we're not-
any idea?
We're not claiming that we receive things by omission. We are claiming that we received it all.
I get that, but how much of the total grant that you're claiming is at stake in this litigation?
All of it. I mean, it is, we were assigned all rights, titles, and interests.
They agree you were assigned something. So what's the
Yes,
difference
all of what?
between what they agree you were assigned and what you claim you were assigned as a percentage of the total?
Again, I can't put it in percentage terms, Your Honor, but I
Can
can
you give me a
say
range or
that it's all of the rights, which is shallow and deep. And I don't want to lose sight of the summary judgment order that brings us here today, which is Oxy pitched this to the trial court as shallow versus deep. And whatever the correct answer is, it isn't shallow versus deep. It just doesn't work with the pleadings. It doesn't work with Exhibit A. It doesn't work with the assignment. And so we're left to look for the textual indicators or clues to answer the all of what question.
It's interesting that nobody's arguing for evidence maybe 1987 is too long ago. I mean, I don't know what the evidence would be, but at the time this was done, surely both parties knew whether they were granting, whether this was a quitclaim deed or whether column 4 of Exhibit A was essentially the grant. I mean, that would have been clear to both sides, and I would think if we dug into the evidence a little bit, we'd have an answer that would be the right answer.
Well, both parties have stipulated that it's unambiguous. That's obviously not binding on this court, but to date, everybody's operated from the assumption that this is, and the understanding that this is unambiguous. But if you want to look at context, let's talk about the context of an assignment accomplished in 1986. Before the advent of directional drilling, before the advent of the fracking revolution, in the middle of the oil bust, where depth descriptions or references to particular shale formations weren't a gleam in George Mitchell's eye at that point. This is an assignment done in 1986. It was essentially Shell cleaning house and getting rid of a bunch of leases that it no longer wanted. And it got rid of all. It was cleaning house, it was not hanging on to anything. I think in terms of context, you may want to consider that's general knowledge.
It wasn't too much later that then they sold the stuff that they thought they still had based on the descriptions in column 4, right?
Well, Oxy purported to do that, but I don't think that establishes anything because Oxy contends it hung on to some stuff, and Citation said, no, our understanding was we got it all, which is why we assigned some of it to Endeavor. So that doesn't really prove anything, and I think where that takes us back to is the four corners of the assignment and Exhibit A.
I want to follow up on what Justice Bland was asking earlier, and I'm in your bench book at page 1868, which is what you had referred us to a minute ago.
Yes, sir.
Okay? So just looking down column 5, there are two listings of .162500 overriding royalty. Do you see that?
Yes, sir.
All right. So just take the first one of those and move over to column 6.
Yes.
It describes a farm-out agreement by and between Allied Chemical and Shell Oil dated November 26, 65.
Yes, sir.
And you've pointed to 2193 in the record.
Yes.
That is that agreement.
Yes.
If we go to 2193 in the record and look at that farm-out agreement, does that agreement give to Allied a .1625 overriding royalty in the minerals produced in Block A down to 8,500 feet?
Well,
is that what that agreement does?
It contains, it's a farm-out agreement, and so it contains depth references about what you earn by drilling. And so to answer your question directly, let me quote the farm-out agreement directly, that it is the assignment of all of assigners' right, title, and interest in and to the oil gas rights in and under the oil gas leases and oil and gas mineral estates held by the assignor in Reagan County, down to and including but not below a depth of 100 feet below the depth penetrated by the well specified in section 3 hereof, to wit, and then it's got a track description. So I think...
Does that track description refer to 8,500 feet?
Yes, if you go further down on the farm-out agreement, it has a reference to well depth sufficient in Shell's opinion to adequately test the Wolfcamp formation expected to be encountered at an approximate depth of 8,500 feet below the surface.
Because if that's the case, I mean, you see what we're getting at then is that basically columns 4, 5, and 6 describe the limitation of the grant. In other words, I'm granting you everything in this lease subject to what I've already given someone else in the farm-out, Allied, in the farm-out agreement, which relates to the 1625 overriding royalty affecting the down to the depth of 8,500 feet. Is that
the way that I understand it, and the way that I think is most accurate from my perspective, is to say that there is no depth limit in the conveyance of the leases, the leasehold estates, from Shell to Citation. There are various burdens that exist on the the assigned leasehold interest, generated by farm-outs, by unit agreements, and so on and so forth. And those burdens create the depth references, but those, and they got to be dealt with because, you know, Citation's getting only what Shell has to assign it, and those assigned leasehold interests are burdened however they're burdened. But those depth references reflect burdens that accompany the leasehold interests. They do not limit the depth of the leasehold interests themselves vis-a-vis a conveyance or an assignment from Shell to Citation. That's what we're trying to get across. And that I see my time is up.
Go ahead.
May I complete my answer? And that's why I direct the court back to the first specific grant, the second specific grant, and the general grant. Because to the extent the court believes there's any lack of clarity in the four corners of Exhibit A, we go back to the Piranha analysis, we sync it up with the assigning language, and the assigning language says all rights above and below, and that only makes sense if the leases cover above and below. And so we end where we began, which is the proposed shallow versus deep dichotomy simply does not work, and for that reason, this court should affirm the Court of Appeals judgment.
Any other questions?
I
Yes.
have one more, if I may. So to go back to my question that you were addressing at the beginning of your argument then, in light of what we've just discussed, looking at that same line where you've got the farm-out agreement, you would say that those two leases that are listed in column 1 include more interest than a 0.1625 ORI, and is that right?
Yes, I mean, it's whatever Shell had to convey, yes.
Okay, and then also, what about the geographic descriptions on the surface? Section 6, northeast, I can't read if that's half or quarter, but northeast quarter, did those leases cover more land horizontally than in some cases than what's described in the tract description?
Yes, sir. I mean,
Okay.
the tract is not the lease. The tract is a subpart of the leased acreage. And I want to make one other point, if I can, in response to your question, which is the court also has been presented with a contention reflected in the oral argument exhibits that somehow there are gaps. There are certain white spaces that appear in Exhibit A, and so that means there can't be any associated contracts with them. And I would direct the court specifically to the first page of tab 3 in Oxy's oral argument exhibits. That's shown as page 2609 from the clerk's record. And you'll see highlighting there that indicates, hey, wait a minute, there's no document listed in this column. What's missing from this oral argument exhibit is the prior page, page 2608. And what page 2608 contains is the documents that are listed and then continue across the pages. So my point is, I'm going to underscore the importance of doing what the court is going to do anyway, which is to look at the entirety of Exhibit A and the entirety of the assignment together and in context. And that goes to the point that you made, Justice Busby, that, you know, subject to can't be just plucked out and given a magical meaning. It depends on the context. The context here demonstrates that it does not perform the function that Oxy would have it. This document does not have insofar and only insofar language or other indicators of limitation. And in fact, it says rights above or below, and that confirms that the Court of Appeals judgment was correct and should be affirmed.
Any other questions? Thank you, Mr. Boyce.
Thank you.
Ms. Stokes, you have 5 minutes.
Yes, Justice Boyd, to your question about whether we can line up the depth limitations with the agreements in 6, it doesn't work even in the example that Citation relies on. This page 1868, you'll see there's one depth limitation that says down to 8,700 feet. And at page 1828, note 2 of the record, they admit that they look at the well maps, they look at the Railroad Commission well records, They look at the Tamarack farm-out agreement, and they construe that as really being a depth down to 8,400 feet. And so they admit it doesn't line up with their 8,700 feet. And then again, there's
Well,
others.
why wouldn't that just be the reason for the second paragraph 3 saying, regardless of whether same may be incorrectly described or omitted in Exhibit A. Some may not line up perfectly, but the intent was to say, we're granting you everything we own in these estates, meaning leasehold interests. But it's subject to what's described in Exhibit A, which is what we've already given to Allied through this farm-out agreement, which we've tried to describe in column 4, but we may not get it exactly right every time. And you see what I'm saying?
Yes, I
And
understand what
that's-
you're saying, and I think, but even on the face of Exhibit A, there's things that just don't line up, like the interest in column 5, they want to say that's limited to whatever the interest is under the agreement. But if you look at 2613 through 16 of the record, they are unit operating agreements that parenthetically list Shell's interest under those unit operating agreements, and they are different interests than listed in 5, which shows you that they weren't trying to say in 5, here's the interest that's burdened by 6.
No, they weren't trying to capture Shell's interests. The question is whether they were trying to capture someone else's interests.
Right, but that would be an exceedingly, why would you list when you're saying, here is me describing the property, and then two of my columns are going to be describing someone else's interests? Those are Shell's interests. I mean, as Mr. Boyce said, it does have an overriding royalty under one of these farm-out agreements that it reserved or earned under these farm-out agreements.
Is that the entirety of what you intended to convey? Is that same overriding royalty that Allied already owned?
No, Shell owned it. So in a farm-out agreement.
Well, but presumably they own more than that under that lease, right?
Right,
More than that ORI. So then why would you only convey to them the ORI that Allied already has? That doesn't make any sense.
No, it's
to
not
me.
Your Honor, respectfully, it's not an overriding royalty interest owned by the farmee. The farmee earns an assignment of the working interest by drilling to a specific depth. And then Shell, as the farmer, reserves a overriding royalty interest in that farm out well. And so that is Shell's interest listed in 5. It is not somebody else's interest.
Do you want to address paragraph 3?
Yeah, the paragraph 3, the one about
All of
rights.
Shell's right, title, and interest in any contracts or agreements.
Sure.
Including rights above or below certain footage depths or geological formations affecting the property described in Exhibit
Yes,
A.
and Your Honor, first I would say the Court of Appeals was not persuaded by this argument. And as Citation recognizes elsewhere, that third specific grant, it is contracts and agreements affecting the property described in Exhibit A. All of these, and it has a, including but not limited to, paragraph that shows this as an illustrative list of the type of contracts that may affect the property described in Exhibit A. And it is not
Do you have a
assigning a
sense-
property right.
Do you have a sense of how much is at stake here as a percentage of the total grant that they're
Your
claiming?
Honor, the record does not reflect exactly what it is all the deep rights, but of the disputed interests. But the record doesn't reflect the monetary value of those because we never got there because the parties agreed to have the judge decide the legal construction of the assignment first. So we just don't know other than that it is the deep rights for all the disputed rights. And I do take issue with the argument that nobody was reserving, accepting, or keeping the deep rights back then. As this court said in the Finley Resources versus Headington royalty case, that was a 1966 instrument where people were reserving deep rights. So they did indeed observe them.
I just go back to, it seems like if we looked at the evidence, this would get really easy. But it's interesting that neither of you wants us to, which tells me maybe it's not as easy as I would think it is. But surely at the time, these people knew exactly what they were doing. And there wasn't ambiguity at the time on this question because it's such a vast difference between the two ways of looking at what this transaction was.
Well, I think the parties knew that they were very specifically defining the scope of the interest, and that's why they said repeatedly, described in Exhibit A, and that's why they gave so much detail, in Exhibit A, and that there's not a way to just write off 4 and 5 as describing 6, which would be a strange way to do it, as coming before the agreement they're describing, and then calling 6 being subject to. But again, also this idea that it's just the entire leases, we were just listing agreements that affect the entire leases. That doesn't work either. There are interests within each lease where there's no agreement, so there would be no point in detailing the depth descriptions. And then there's also different. You can't say that one farm out applies to the entire lease because they often have different agreements for different interests within the lease, but also repeat. There's a place where they repeat the very same agreements over and over again for different depth limits within the same lease. So
Any other questions?
any other questions?
Thank you, Ms.
Thank you,
Stokes. Case is submitted. The court will take a brief recess.
All rise.